Let's bring in our guests on the development in Rivers State. The House of Assembly had started the process of impeachment, and after the governor did not respond by their own submission, they've activated the proceedings and asked the chief judge to set up the panel of investigation that has about 3 months to look at all of the allegations, gross allegations leveled against the governor. Well, the chief judge has now responded to say, due to some court orders and all of that, he will not be proceeding with constituting a panel, perhaps pending the determination of those court processes. Douglas Obankwa is a constitutional lawyer and policy analyst. He joins us virtually from Benin City, the Edo State capital. Mr. Obankwa, thank you so much for coming on the program.
It's a pleasure to be here. Good morning, Nigerians.
I want to read section 188, subsection 10 for your interpretation, whether it's pre-setting of the panel or after setting up of the panel. Subsection 10 of 188 that has to do with impeachment process says no proceedings or determination of the panel or of the House of Assembly or any matter relating to such proceedings or determination shall be entertained or questioned in any court. At what point is the Constitution envisaging that the court should stay out of this? Is it pre-setting the panel or when the panel has finally been activated? Because that is what the other end is arguing, said the court is not supposed to be involved in this.
Brilliant question. Now, you see, the 1999 Constitution of the Federal Republic of Nigeria, as amended by the 5th Alteration, actually is an adoption of the 1979 Constitution. The first real case of impeachment that had a judicial interpretation was the impeachment or the attempted impeachment of Abubakar Remi, the governor of Kaduna State, in the Second Republic. And this same section of the Constitution was also enshrined in the 1979 Constitution, and the court in that particular impeachment process indicated that there is an abstract clause that the parliamentary powers of the State House of Assembly to impeach cannot be impugned by the court. However, after the coming into democracy following the prolonged period of military rule in 1999, there were several incidences of impeachment. Perhaps the first being that took place in Anambra State, where there was an attempt to impeach Governor Chris Ngige of Anambra State. I am privileged to write my long thesis to get my LLB on that particular impeachment process, and I've written a book on the removal of the governor in Nigeria. And to tell you that the position of the law right now is that there are about 11 processes, section 181 to 11, that must take place before a governor can be removed. Now, the authority of Domlong and Plateau State House of Assembly is of the Domlong and Dari is of the authority that where there is any kind of breach by the House of Assembly, that is to say, they did not follow the express provisions of the Constitution. And mind you, those 11 processes are sequential in nature, and there are timelines and there are thresholds. For example, it's only when you have 1/3 members bring an allegation in the House of Assembly that the impeachment process can be activated. And after that is done, the House, with way of a resolution, the Speaker, the Chief Judge, to set up the 7-man panel, which must include people who are not of public service, they do not belong to any political party. However, what we have right now in Rivers State is that we have two injunctions, two ex parte injunctions that have restrained the Chief Judge from constituting the panel. That is where we have the cul-de-sac. This is a novelty that requires some level of simulation at the Supreme Court. And the Chief Judge, in his letter to the Speaker of the House, indicated that aside the fact that there are two injunctions against him to set up the panel that would investigate the gross misconduct against Governor Simfovera. That indeed the case is at the Court of Appeal. And following the authority of the case of the governor of Lagos State and Ojukwu, when a case is in court, parties have to maintain status quo. That is to say, following the doctrine of least spending, once a case is in court, you are not expected to take actions that would compromise the determination of the matter in court. So following our judicial precedent, the Chief Judge has written to the Speaker. So to answer your question, my dear brother, it can be activated at any point. What is important is whether or not the House of Assembly has followed the very rigorous and cumbersome provisions that have been put there. And mind you, the definition of gross misconduct is no longer as wide as it used to be. You see, local Jew and the case that took place in the Osun State case. The Supreme Court indicated what gross misconduct is.
Very quickly.
They were so specific as to what gross misconduct is. As opposed to when Congressman Davenport said that it is what the majority of the House says it is.
If I may come in there very quickly, should we begin to give any interpretation or raise eyebrows as to the position expressed by the Chief Judge, knowing how litigations go in this country? And we could cite a number of cases, the Ibadan court intervention in the PDP matter and the many other, court rulings on the PDP convention. So if this is coming from River State, should we raise eyebrows and say that, there are political undertones coloring the position expressed by the Chief Judge?
My dear sister, the thing is that the court remains the only place where you are sure that process and procedure will play out before a decision will be taken. And I want Nigerians to know that they are kind of, the way they tend to malign our courts. We know that we may have issues with some of the judgments that come out of our courts. However, I tell you, at the end of the day, the court still remains a veritable shield against arbitrary use of power. Now, you also realize that this same court condemned, that the Supreme Court that condemned Governor Simfovera's shenanigans of demolishing a House of Assembly. We have had, and this is very important because we need to begin to interrogate the way our governors run the state. And I have said this severally. If the president of Nigeria runs Nigeria the way our governors run, none of the governors will be governors. It is important for our government that we have three tiers, three organs of government: the executive, the legislature, and the judiciary. And that those three organs of government have its constitutional shares between them. And also, it is also important for them to know that there is balance of power, there is separation of power. And that the reason we have separation of power is so that we will be able to have some balance of power. So the governors most times consume the legislature, and I dare say the judiciary under them. And that is why you see, we find that we must are not governors. In any case, we also need a vibrant House of Assembly. A House of Assembly, what is happening in Rivers is very interesting. A House of Assembly that can call the governor to question. Because what has really happened in Nigeria after the Obasanjo administration is that most governors have the House of Assembly into made government house agency. You have seen House of Assembly meeting the government house. You have seen a House of Assembly, which is in the case in those states, under Governor Godwin Obaseki, being inaugurated by 9:30 at night. So it is important that we all know the democracy that we share. It's right.
All right, Mr. Agbankwa. Yeah, Mr. Agbankwa, great point you've made. Sometimes in Nigeria, the more you look, the less you see. But what we've tried to do is to bring to the fore what the law says and what the law doesn't say. And we'll see how this plays out eventually. It's a pity that a state like River State has been unstable politically since the inception of this administration of similar Fubara, it looks like there's no end in sight. But let's see how things play out. But I must thank you, Douglas Ogbankwa, constitutional lawyer and policy analyst. Thank you, sir, for coming on the program.
It's a pleasure to be here.
We'll take a break, and when we come back, we'll continue with other parts of the conversation on the program. Stay with us.